important piece of legislation. We pray, Lord, for wisdom, and we pray for a balanced view as we look at the provisions and the recommendations from stakeholders. We pray that we'll be able to go through with alacrity and also with clarity. In your name we pray. Amen.
Thank you. Apologies for absence. We do have some from Senator Scott Motley, Senator Fraser Binns, Mr. Mark Golden, Mrs. Dalrymple Philibert, and Mr. Robinson. And from MSET, we have apologies for access to personal. On the last page, page 6, the last paragraph about in the middle, before you get to the bolded section, where it says Ms. Murray supported the position of Ms. Grant and added that the provision was wider than infirmities, because persons outside of the country might need someone in the country to act on their, should be on their behalf, right? Yeah, by letter of authorization. All right. Any other corrections to any of the minutes, the one for July 24th or the one for July 31st? If none, we ask for confirmation. Moved by Senator Carencia Morrison. Seconded by Senator Pernell Charles Jr. Any matters arising from the minutes? If none, we'll move quickly into the matter for discussion, clause by clause analysis of the bill, starting with clause 6, right of access to personal data. And I think this begins the rights that we have as data subjects. This is the first right, the right to know what data is being collected about us. So Ms. Kadian Newton.
Thank you very much, Chair. In looking at clause 6 of the bill, Chair, as you would have indicated, clause 6 speaks to the right of access to personal data and speaks in particular to the right of the data subject to be able to access certain information free of charge, certain information for a fee, and also to complain to the Information Commissioner if the data controller fails to comply with what is popularly called a subject access request or fails to comply with a request that has been made by the data subject. In relation to the concerns which were raised, Chair, on this clause by various stakeholders, stakeholders raised concerns, in particular the Jamaica Bankers Association, about financial records or financial data, and indicated that the way the clause is currently worded, the clause would allow that information which it considers to be confidential to be shared with other individuals who are not customers of the bank, since in the earlier clause 5 we indicated that representatives could make a subject access request on behalf of a data subject. Additionally, some stakeholders raised concerns about how these fees that would have been prescribed, how they would be calculated, and whether or not the fees that would have been prescribed with or without consultation. Concerns were also raised about the time period within which a data controller would be able to comply with a subject access request versus the time period that was given to a data subject to complain, and also the requirement as well for the option for the Information Commissioner to refer a matter being investigated by him or her to a mediator. And since a mediator is being used, what if any were the characteristics or the qualifications of this duly appointed mediator? So, Chair, to take us through the concerns one by one, the matrix is here. We'll start first with relation to the concern raised by the Jamaica Bankers Association with respect to banking information. And you'll note that based on our research, we did not see where in any jurisdiction banking information would have been exempt from a subject access request, and we did not think that the bill should be amended to create an exemption from for banking records for subject access requests. We didn't support the Jamaica Bankers Association in that regard. With respect to the fees, Chair and the committee members, your attention is drawn to Section 6, Clause 6, subsection 5 on page 15 of the bill, which provides that different amounts may be prescribed for different circumstances and different periods may be prescribed for different circumstances. The concern that was raised was whether or not what would be used to determine essentially what fees would be charged for which circumstances, and whether or not complexity would determine whether or not you would charge fees for certain types of information and fees for or higher fees or lower fees for other types of information. And the truth is that matter is one that will be determined by the minister in regulations, and usually the fee structure is determined based on one example is complexity, and we would not prescribe that in a bill at this point in time to say complexity will determine whether or not the fee is high or the fee is low. You simply indicate that fees can be charged, can be differentiated, and at the point in time when the regulations are made, the fees will be determined based on consultation. With respect to time periods, that would be Clause 6, subsection 4. The legislation currently provides that the data controller has 30 days to respond to a subject access request. The concern that was raised by some stakeholders was that if they were supposed to respond promptly, 30 days is not prompt. And then we had other stakeholders, and that would have been Lawyers Christian Fellowship, for example. And yet still you had other stakeholders, such as Flow, which would have raised that 30 days was too short, and they felt that we needed a longer period of time to allow the data controller to respond to a request, because you may have to go through volumes of information or reams of data in order to respond to the request. And they recommended that the period should be at least 40 days. Chair and committee members, while we believe it's a matter for the committee, the ministry recommends that the period of 30 days remain. Based on our research, we found that, generally speaking, 30 days was within the remit of what other countries would have provided for. So we found, for example, in Canada, the period was 30 days. Trinidad and Tobago, the period was 30 days. St. Lucia, 30 days. Within the EU, many of the countries, 30 days under GDPR. Antigua and Barbuda, 30 days. You did have a few states that had 40 days, the UK, for example, and the Bahamas. But we still felt that 30 days was relatively prompt, gives the data controller adequate time or sufficient time within which to respond to a request from a data subject. And again, we're talking about a right that the data subject has, and we wouldn't want the data subject to have to languish waiting on a response from the data controller.
For those jurisdictions, through you, Chair, do they have the ability to request extensions of time?
Yes, in some of them they do. Yes.
Because I think the gravamen of what is being sought here is really for there to be no sanction if it is that you don't comply within 30 days, if you have some justification for not complying within the 30 days. So is there a structure that you would have seen coming from those jurisdictions that would facilitate that?
Well, currently, what our bill provides is that the period of 30 days can be such a longer period as may be prescribed. So at present, the period isn't limited to 30 days. 30 days is just the start. It could be a longer period if, in a particular circumstance, it is anticipated that more time is necessary. So, for example, in 6.5b, the bill currently provides that different periods may be prescribed for different circumstances. So there could be circumstances in which from the get-go it would be longer than 30 days because it is recognized that that particular request may require more than 30 days for a data controller to respond to it at that particular point. So there is a measure of flexibility within the legislation already. Manny, I hear you saying something.
Okay. So again, for clause 6, it's the new right that we will have to access our data. And we're saying to the persons who collect information about us that within a reasonable period, and we have determined 30 days is a reasonable period to provide that data to us.
That's correct, Chair. And again, 30 days is what the bill provides for now, but it does recognize that if there are certain circumstances that require a longer period, the minister can prescribe a longer period of time in those circumstances. So it may just be, I'm not saying this is one, but it may just be that because of the nature of phone records, for example, and phone data, that type of data may require a longer period than 30 days, and that is something that could be prescribed if it is required. Chair, continuing with respect to the recommendation in relation to a mediator, on page 15 of the bill, which is clause 6.8, the clause currently provides that a commissioner may appoint a duly qualified mediator to consider any matter to be determined or inspected. I'm adding the words by him. The concerns raised was that we want to define who is a qualified mediator and what are the characteristics essentially of a qualified mediator. And another concern was why is it that we need a mediator in the first place? Why can't the information commissioner just make his or her own determination of the matter? With respect to the first concern, we didn't think it was necessary for us to define who is a duly qualified mediator. A mediator is one who I believe that within our own the context of our jurisprudence, you go through certification, and certainly whatever the requirements are to be considered a mediator, we think that we should defer to what those requirements are and just to use the terminology that is there. In fact, what we indicated in the matrix was that words are to be construed using their ordinary meaning unless a contrary meaning is intended, and we didn't think any contrary meaning outside of what is the current definition for mediator or current understanding of who is a mediator ought to be placed in the bill. Similarly, we felt that the use of a mediator, though we recognize that this wasn't very popular in other legislation, we found that the use of a mediator here gave the Information Commissioner an option as to how to resolve a dispute between the data controller and the data subject. And so it was just providing the Information Commissioner with another avenue by which to deal with a particular dispute as to a subject access request, rather than to require the Information Commissioner to be dealing with perhaps reams of complaints that may come in from data subjects in relation to this matter. So we thought it was a good alternative, and we didn't think that it ought to be removed from the bill. And if there are, finally, Chair, I don't have any comments. Chair and members, if we look at, I'm on page 14 of the bill, clause 6, clause 6.2c, we'll recognize that the scheme that is provided says two things. The first scheme says that just knowing that the data controller has information that is processing on your behalf is information that you can obtain for free. Just the knowledge that someone is processing information, you can obtain that for free. You can also obtain information about the purposes for which your data is being used, as well as the class of person or persons to whom that data is likely to be disclosed. That information is for free. Information that you have to pay for is information which requires, for instance, information where you require, for instance, the logic which is involved in a decision that has been taken in relation to you. So if it is that your data has been processed automatically, for example, and there's a result or a decision, then you have the right on payment of a fee to find out the logic that was behind that particular decision that has been taken. Similarly, you also have the right for a fee to find out the source of the information, as in the source data itself, as well as the individual or individuals from whom your data has been received by the data controller. So I mentioned that because in relation to 6.2c, the bill currently provides that you have the right to have communicated to you data in an intelligible form upon the payment of a prescribed fee. It was the view of the ministry that while intelligible form was sufficient to deal with persons who do not have a disability, that perhaps it would not be wide enough to cover persons who have a disability, and we want it to be very clear in this particular provision to ensure that persons with whether a visual or auditory disability could also have information provided to them in a form that they could be able to easily understand. And so we found in some jurisdictions that they use the word intelligible and accessible in relation to how the information ought to be provided. And so our recommendation is to insert the use of the word accessible after the word, insert the accessible as another form. So you would see to have communicated to that individual in an intelligible or accessible form upon payment of a prescribed fee. Unfortunately, when we did our research, we found that in the jurisdictions that use accessibility, they didn't go much further than just to insert the word accessible, essentially in the legislation, leaving it, of course, to the data controller to implement accessibility in the provision of the data, the information that would have been requested. So in our estimation, we envisage, for example, that if information was being provided to a data subject who is, for instance, visually impaired, that the data be provided in such a manner, it could be in an electronic format, but it could be provided in such a manner that it would allow for any text-to-speech software to be able to read the information when it's provided to the data subject, because there are some methodologies that if we, for example, scan the data in a particular way, it cannot be read using that particular software. So we felt that it was important, in light of important to include accessibility as a very specific and clear part of the right of access, in particular for our citizens who have a disability.
Can you just back up just a bit? Did you say that that would have to be a service that it would be paid for, or that is not a paid service?
At present, where it falls, it would be a paid service, unfortunately. So right now, where it is because you are paying for, and let me just put it in context. Where we're inserting accessibility is at Clause C. I know, and at Clause C, no, and remember, let me explain. Where we're inserting accessibility right now, it's at Clause C. And what you're getting in intelligible and accessible form, it's not just information generally about you as to what the person is processing. What you are actually getting is the background information about which would have formed a part of what the data controller has, and also any information as to the source of the data. So you're going a little bit deeper. So across the board, and we wouldn't want to, well, I wouldn't recommend that we create a differentiation on this part with respect to persons who have a disability versus persons who do not. And at that point, everyone is paying for that information. We're just saying allow it to be accessible.
Good. I think I wanted clarification for that, because I would oppose to something like that, but you've now cleared it up. Thank you.
Sure.
Okay.
SG?
All right. Okay, so if there are no objections, we'll move on to Clause 7, manner and extent to which information shall be supplied under Section 6.
Right, Chair, This particular clause just simply outlines that where a subject access request has been made, how it is that you are supposed to provide this information to the data subject. It's not dissimilar from an access to information request, essentially, and outlined in that legislation how it is that the information ought to be provided. And so it speaks specifically to say that where the information that has been requested by the data subject is not possible or would involve disproportionate effort, and the data subject agrees, then this information can be expressed in terms which are not intelligible without explanation. Then you have to provide an explanation for it. And so let me step back a little bit. Recall a while ago we would have indicated that if you want information which is a little bit deeper than just what do you have about me, what are you processing, and who you're giving that information to, if you want the source of that information, for example, and the background information, you have the right to request it for a fee. If, however, it's not possible to provide that information in intelligible form, if when you give it to the person you're not able to do so, then you must allow that information to be accompanied by an explanation. The concern that was raised by one of the stakeholders is whether or not the information had to be in a physical form because it said you're entitled to be provided with a copy of that information. And I guess in Jamaica, an understanding copy simply means a physical document that you have to be given. And what we said really is that there is no mandate that this copy had to be in a physical form. You could be given it in an electronic format as well. So we just provide an explanation. Chair and members, you would realize that we did suggest as a ministry the insertion of the word accessible as well in this clause. And so we were suggesting that where information could not be provided in an intelligible and accessible form without explanation, the copy should be accompanied by an explanation of the terms. On review, we are not recommending the insertion of the word accessible, so we are asking you to disregard that particular recommendation. The reason being, what the clause is seeking to indicate is that if you're to provide information in an intelligible manner, so that the data subject can understand the information without more just looking at it, if you find that you're unable so to do, then you need to provide an explanation so that when the data subject looks at the information along with the explanation, he or she will be able to understand essentially what the data is saying. This is not an accessibility issue, it's an explanation issue, and so we didn't think that you needed to insert the word accessibility there.
What we're treating with now is a separate matter from the accessibility that you dealt with before, right?
That's correct.
All right, members, if there are no objections to Clause 7, we move on to Clause 8, and this clause allows the data controller to not comply with certain requests, depending on whether or not, if they do, it would reveal information about another individual, for example. So, Ms. Smith?
Thank you very much, Chair. That was an excellent summary. That's exactly what the clause has said. I would just bring the committee to Clause 8.5. So Clause 8, subsection 5, outlines the circumstances that the data controller would consider in determining whether or not he or she should comply with a request from a data subject. As the chair would have indicated, as a data subject, there are times when you may request information, and in that request, essentially, there's a possibility that data about another data subject could be revealed based on what you would have asked. Some information about a child may request may involve information about a parent, for example, just the nature of the relationship.
Or husband and wife, or divorced or something like that. You know, they may request, a wife may request information, and if you give it to the wife, then there's information that she would know it's the husband or...
That's correct, Chair. So in 8.5, there are certain circumstances that the data controller ought to consider in determining whether or not he or she will reveal that information to the data subject, notwithstanding that it could reveal information about another individual, and the 4 circumstances are listed here. The Jamaica Bankers Association has asked the committee to consider that a 5th ground be added to the grounds here, that the data controller should consider in determining whether or not to reveal information to a data subject that will reveal information about another individual. They should consider risks associated to the personal safety of the other individual or his or her family. So basically take into concern whether or not there are any risks to that other individual by revealing the information to you. We have the research that was done internally did not reveal any provision of the manner or in the form that would have been suggested by the Jamaica Bankers Association. And as such, the ministry is not recommending that there is any change to this clause or that this addition be made. And the reason is really twofold. One, this is not a personal safety regime that we're looking for. We're protecting personal information as a proprietary right or personal data, and so we wouldn't recommend that we include words that connotate personal safety. But more importantly, personal safety is something, the way it is structured here is it's onerous and it's also very subjective. How will a data controller be able to assess essentially whether or not revealing a particular particular information will affect personal safety of that individual and or his family. It's taking it really too wide and too far. And we didn't think that this should be a duty that should be imposed on a data controller. And so it's not our recommendation that a subclause 5E be inserted to deal with personal safety as suggested by JBA.
Thank you. Do you want to move on to, if there are no objections, we'll move on to clause 9. And I believe there's a recommendation for this clause to be moved to another part of the bill.
Thank you very much, Chair. As currently stated, this particular clause would have provided in the way it's worded on an exemption for public entities or public authorities in relation to manual records which are not kept in an organized method or an organized system. The ministry and the research team at the ministry would have looked at this clause and would have recommended, and perhaps I should go one step further than where I went earlier. So to say it again, this particular clause provides an exemption for manual records which are not held in a very organized manner by a public authority. And it would have given, this is additional point, would have given that public authority the opportunity to, for want of a better word, deny a request or deny complying with a request on the basis of cost. That it would have been too costly essentially for that entity to be able to look for the information if you did not give a description of the information. It was our view at first that we would delete subclause 3 to 6, and because we didn't think that cost should be a determining factor as to whether or not a data subject should be able to access information held by him or her in a public authority or by a public authority. And hence the recommendation was for subclauses 9, 3 to 6 to be deleted, and we would have kept 9, 1, and 2. However, when we look at subsections, clause 9, 1, and 2, 9, 1, and 2 simply indicate that where the data control is a public authority and a request is made by a data subject, that the data controller is not obliged to comply with the request unless there is a description of the data. We felt that in clause 8.1, which we passed just earlier, already made provision for that, because essentially under clause 8.1, a data controller can refuse a subject access request where it is that the data controller requires more information from the data subject and he or she has made that request of the data subject already. And so 8 subsection 1 and 9 subsections 1 and 2 are basically making the same provision or providing the same right. In that regard, it is the recommendation of the ministry that we delete clause 9. Delete clause 9 in its entirety.
Okay, so by deleting it, we're not exempting anyone because they have a manual system, right? Because remember, we're given a transition period as well, right, for entities to get their data records up to date.
What are the implications of deleting clause 9 on the government in terms of the cost to taxpayers?
All right, so presently, in its current format, clause 9 would have allowed the government to be able to indicate that because of and this is again where data is not kept in a particular manner. So there are 3 types of ways data can be kept: electronic, in a manual system which is relatively organized, and just literally the third way is in no organized system at all, just data just exists where data is. If it is that one concern that has been raised, I should say, was that the government was seeking to exempt itself from the provisions of the data protection legislation by virtue of this clause, because one thing the government was seeking to do was provide an exemption where it had records or manual records in its possession. Flow, for example, had suggested that this particular clause ought not to be limited to just government, but it in fact should be across the board, that both public and private sector entities where they had data which was not electronic, not manually organized, but essentially just organized in a random way, my words, that information ought properly to be the subject, should be the subject of this particular exemption as well, so that public and private entities would be able to indicate that because of the cost of trying to locate this information, we did not have to comply with the request that was made by the data subject. It was our view that when we looked at this particular clause, that even though there is a cost implication on the entity, that all data controllers should be required after a particular period of time to comply with the requirements of the legislation, and therefore should be able to comply with any request that was made by a data subject across the board. With respect to the cost, honestly, we're not in a position to indicate at this point in time what would be the cost to the government, essentially, as in a dollar figure, the cost to the government. But what we will say is that the government is currently on a path of digitization, where it is seeking to move its records from a manual-based records to electronic records. And over time, as this process continues, the records of the government will become more organized and also in digital form, and therefore more easily accessible. The legislation currently provides for a period under Clause 39 of 2 years to deal with manual records currently. And that period, and we can turn to Clause 39. That period of 2 years is an exemption, which is a temporary exemption, which is provided for data which is held by public authorities. And so, independent of Clause 9, public authorities would be able to have an exemption in relation to aspects of this legislation, including the standards, including some of the subject access requests, essentially, that would have been made by a data subject under this legislation. And so we felt that between Clause 39 as well as Clause 8, subsection 1, that adequate provision would have existed for what we sought to do in Clause 9, and hence we were suggesting that it should be deleted.
Okay, if there are no objections to deleting Clause 9, we will move on to Clause 10, which is a right to prevent processing likely to cause damage or distress. And as an example of that, it would be, let's say Facebook kept your information even after you asked them to deactivate it, right? If something is out there on you that is causing you distress, you should be able to ask for it to be deleted.
Or for them not to process it, or to process it.
Or for them not to process it. Is that maybe the more correct terminology? Yeah.
That's correct. All right. So this clause, Chair and members, would have been the subject of a lot of comments. The comments tended to be relatively the same. One was that the stakeholders felt that there should have been a definition for the words damage or distress, and that the terminology damage or distress was relatively subjective. What exactly is damage? What exactly is distress? And therefore there ought to be some definition that was given to the term. They also felt as well that there should have been, and one stakeholder in particular, I should say, felt that we needed to look in Clause 10.2b at this word irrelevant. And 10.2b gives another circumstance, and I like to do an overview of the particular clause first before I go into it. So Clause 10 basically says, if it is that a data controller is going to process information that it has on you, you have a right to tell that data controller, look, please stop processing. And here are the circumstances. One is that the data that you have on me is incomplete or irrelevant, that the processing that you're seeking to undertake is prohibited by law, that the purposes for which you had obtained my data would have expired and you are no longer allowed to retain that data for any period of time. Those are, or as Chair would have said earlier, that the processing of this data is likely to cause me damage or distress. Those are the circumstances. Again, one stakeholder indicated damage or distress is too subjective. We think we ought properly to provide a definition of what damage or distress means. Another stakeholder indicated that what does it mean when you say that the data which you're processing is irrelevant, because essentially relevancy is subjective, and how do you determine essentially when the data that the person has or the data controller has is relevant or irrelevant. Another stakeholder indicated that we ought properly to insert a provision that simply says that where you have obtained the data unlawfully, then I have the right to tell you to stop processing completely. And then another stakeholder indicated that there are times when you would have obtained the data lawfully from the data subject, perhaps even with consent, and should the data subject tell you to stop or to cease processing, it would cause a problem, or your systems will not allow you to be able to stop or cease processing based on the time that the data subject would have told you to stop or cease processing. And it was that stakeholder's view that there should be a prohibition, or I should say a limitation on the right to prevent processing where there are legal obligations or contractual arrangements. And as a ministry, we looked at all of the recommendations or the suggestions that were made. The first, we did not feel that there should be a definition for the terms damage or distress. And on this, I know the SG is here and the CPC is here, but it was our view that when we assessed the legislation of other jurisdictions, that they did not define the words damage or distress, but rather they left it open for interpretation as to what would be damage in one circumstance and what would amount to distress. And we didn't think that we ought properly to define that particular terminology in the legislation. And I'll pause.
I was wondering why you have to use both words, because I believe that distress is a consequence of damages. So I don't think.
Or damage is a consequence of a distress.
Right. So
but I can be damaged without being distressed, I suppose.
I wouldn't think so. I wouldn't think so. I'm waiting.
Okay. The CPC is sharing that based on the nature of the words and applying the ordinary meaning, damage and distress, you can have one without the other. And so to ensure that you cover all bases, it's suggested that you use both. That there are some circumstances where you could have damage, and the damage that was not caused as a result of distress. And I can also go on to say that you can have distress and perhaps damage alongside it, but I suppose in the first instance, because one can stand without the other, you put both together. Anything else?
Could you remind me of your recommendation again? You articulated a recommendation. Could you remind me?
We are not recommending that we have a definition for the words damage or distress. The stakeholder was suggesting that we needed to define the word damage and define the word distress, or in particular define what distress really meant. I think damage was a little bit, it's more innocuous. Damage is more easily understood. The concern is what amounts to distress. And they're asking us to define distress, and it's not our view that the word distress ought to be defined and that it should be left to development and interpretation over time. Because what could be distress in a particular set of circumstances may or may not be distress in another set of circumstances, and so to try to circumscribe it, even if you use the word include, you could limit essentially what is the extent of what distress really means based on the circumstances.
What's the legal meaning of distress? The standard meaning in our, is there a meaning in our jurisprudence?
I don't think so. I'm hearing you want to. It's not a legal term of art in our legislation. It's just the ordinary meaning of what it is that distress means.
if you may just then clarify, what will then the clause, how will it be read? As it's written, we'll just leave it as, okay.
If I may, Chair, what was the resolution on the matter of relevance?
Okay, so we're coming to that one next.
Okay.
We're coming to that one next. Just a moment. Thank you very much, Chair. We were just looking at another formulation. The GDPR uses words such as material and non-material damage in a similar clause of this nature.
Can you define GDPR?
Sorry, Chair?
Can you define GDPR?
The General Data Protection Regulations, that's the EU's data protection regulations. It uses the term material and non-material damage. However, because of how it is that our jurisprudence has developed, damage usually suggests some type of harm or something happening, so that even including non-material and material, you may already be inserted into our jurisprudence terminology that is foreign and unknown. And so the recommendation is that we leave the words damage and distress as it is, and that we do not define them any further because they're not terms of art, as the SG would have shared, and that the natural ordinary meaning ought to apply. The other recommendation, Chair and members, would have been in relation to, my apologies, would have been in relation to, I'm still on page 19, 10.2b, where the data is incomplete or the data is irrelevant, then those are circumstances that you ought properly to you have the right to indicate to the data controller, please stop processing or don't even begin processing my data. Again, the word relevance is determined based on the circumstance. Now, if we read the clause is saying that the data subject has the right to tell the data controller that because the information that you have on me is irrelevant having regard to the purpose of the processing, then you ought properly either not to start process or cease processing. As we'll come to realize further on in the legislation, that one of the standards that the data controller ought to abide by is that you are supposed to indicate what are you going to use the data that you have collected, what you're going to use it for, or what is the purpose for which you're going to use it. Hence, relevancy is determined not as an arbitrary term, but it's going to be adjudged against what did you tell me you are going to use my information for. So in our remarks, you would have noted that as a ministry, we agreed that the term relevancy could look subjective, but relevancy is not standing on its own. It's standing in the context of what the entire legislation says. And if you would have indicated to me that you are using my data for X purposes, or you're going to process my data, for X purposes, then if you're going to process it for Y purposes, then in those circumstances, it would be irrelevant. And the data subject ought to be able to say to a data controller, you have to stop processing my data or don't even begin processing my data. And so it's not our recommendation, again, that the word relevant needs to be defined. It's not a term of art, it's an ordinary word. And that in the context of the legislation, relevancy is not subjective.
So that was clause 10.
We're not,
If
no,
there are no objections,
No, we do
you
have
an objection.
We do have another.
How can it, I understand what you're saying, but how can it not be subjective?
How can it not be subjective?
Subjective?
What?
How can it not be subjective?
And okay, so let me ask, if I may, Chair, could I ask the member to explain a little further when you say not subjective? When you say it's not subjective, could I ask you to explain a little further?
No, I'm saying, based on what you are positing in relation to the comments, you're saying that the word is not to be interpreted in a way that is subjective. Mm-hmm. And I'm saying I'm not sure how it cannot be. I mean, in practicality, even if it is that you juxtapose relevance based on what somebody suggests they're going to do and then what they have actually done, it still goes down to subjectivity. So, but I'm really speaking in relation to what was said. What was said is that relevance is not to be seen as subjective. Well, I'm saying there's no way it cannot be subjective. That's the difficulty. So I'm not sure if what we're doing, does it remedy what you're trying to, well, what has been suggested rather, right? Is to include it, correct?
No, we are what was being suggested is that we need to either remove
to exclude it, sorry,
exclude
right?
the word relevant.
And you're saying that's not necessary because it is not to be seen as being subjective in its interpretation. Am I correct?
Yes, you are. Yes, you are. And the subjectivity is because it's not standing on its own. The words in the legislation say that the data is incomplete or irrelevant having regard to. So it's qualified by what comes behind. It's having regard to the purpose of the processing.
I mean, at the end of the day, there's really no way of going around it, unless you remove it. But I mean,
right. And with respect to having regard to the purpose of the processing, in clause 25(1), which is the second standard indicates that the personal data shall be obtained for only one or more specified and lawful purposes, and those purposes must be specified in information which the data controller ought properly to provide to the information commissioner, to the data subject, or in particulars given to the information commissioner. And so from the very beginning, or certainly on request, the data controller is to indicate essentially what they're going to be using your information for from the beginning, from the get-go. I wouldn't say it would be redundant, because I believe that the purpose for this clause is to say, if it is that you have information for me which you are processing, and you're processing outside of the purposes for which you would have indicated that you are going to process my data at the very beginning, then I have the right to tell you to stop processing my data, because you would have indicated the purposes for which, if I went and I made my requests, I would have found out that these were the purposes for which you would have indicated you are collecting my data, processing my data, all of those, and then when I check, you are actually doing it for some other purpose, then I should have that right to tell you to not to process if I find out before you start, or if you're in the process of processing, to tell you to stop processing my data at that point in time.
All right, we can return to it if needed. Thanks.
One moment, Chair. Chair, we're still on Clause 10, just before we move on. There was another concern that was raised in particular by Lawyers Christian Fellowship, so I'm on page 42 of the matrix. 42. Lawyers Christian Fellowship would have raised that there should be an additional ground which is inserted in legislation to say that you have the right to tell a data controller to stop or to cease processing where the data was unlawfully obtained. When we looked at the clause, we were of the view that there was no need for an additional insertion, because currently clause 10 stipulates, and I'm reading from the recommendations now, Chair, that that the right to terminate processing where data are unlawfully obtained is already contained in clause 10, as this clause makes provision for this as one of the grounds to require the data controller to cease processing is where it is that the processing is prohibited under any law, including under the Data Protection Bill. So we are of the view already that the concern that was raised about unlawfully obtained data, it suggests that this is data which is obtained contrary to any law at all. And one of the grounds for which you can ask the data controller to stop processing or to not to begin processing is where it is that the processing of the data is itself prohibited under any law. So we're of the view that it was already covered under the existing provisions in the legislation and no further amendment was required or is required. However, when we did our assessment based on what happens in other jurisdictions and just looking at our legislation, we were of the view that the circumstances that are listed here currently explicitly point out the circumstances under which a data subject could indicate to a data controller, please stop processing. And all of these circumstances, all of these situations listed here were linked to something. It was either on data which you didn't have the right to process by law, it was incomplete or irrelevant, it had to cause me something, damage or distress. What if I just didn't want you to continue? I just want you to stop. It's my information, it's my proprietary right. I believe you ought to just stop processing my data, or I change my mind, I don't want you to process my data at all. And we felt that as currently worded, it wasn't explicit that the data controller would have had a right data subject, would have had a right to indicate to a data controller that I'm withdrawing my consent that I gave earlier for you to process my data, and I would like you to stop processing my data at this particular point in time. And so we were recommending that there's an adjustment to clause 10 to insert a right for the data subject to indicate to a data controller that I have withdrawn my consent and you no longer have the right to process my data anymore. And why we have to mention consent is that when we get to clauses 23 and 24, we'll realize that under 23 and 24, which is linked to clause 22, that one of the bases for determining the first standard, that is data is lawfully and fairly and lawfully obtained, under the lawfully part, there are some circumstances that we list to indicate when data is obtained lawfully. One such circumstance is where you obtain the data by virtue of consent. And if it is that you obtain data by virtue of consent, then I should be able to say, I'm taking back my consent and I'm withdrawing it. So you no longer have my consent, and therefore you ought to stop processing my data. And while as a ministry we would have recommended the adjustment at clause 10, I believe that the CPC, from a drafting perspective, believes that this particular amendment is better made later on in the bill at between clauses 23 and 24? In 23. Clause 23. So just for the purpose of the committee to note that even though we would have recommended, the recommendation is made here that in relation to drafting perspective, you will see the adjustment being made at clause 23 of the bill. An adjustment being made.
Just a quick question in relation to going back to the suggestion from the lawyers, Christian Fellowship, as it relates to clause 10.2, which speaks to data which was unlawfully obtained. So what we're saying is that the data unlawfully obtained would be subsumed within 10.2c, which is the processing of the data, or the processing of the data for that purpose or in that manner is prohibited under any law.
That's correct. Yeah.
So D, which is the data that has been retained, would also be.
You could, in circumstances, it wouldn't. If it is retained, it wouldn't have been obtained in circumstances which are unlawful, that you are keeping it longer than you are supposed to.
What my concern, for persons who are reading the legislation, who you want to have a very clear perspective to them as to what should or should not be the parameters within which it functions. Would it be useful? I mean, does it do any offense or damage to delineate clearly that if it is unlawfully obtained, it also, as a separate, would that do any damage to it? Would it help from CPC, I'm asking, in terms of the legislative ease of the reading? Do you think it would help to have it separated?
Why would it not be covered by the language that's already there, that the processing of the data is prohibited under any law?
All right, so I didn't articulate myself properly. I'm not suggesting that it is not. I'm not contradicting that at all. I agree. I'm asking, in your professional view, for persons reading this, do you think it might help them to have it separated out, or will it cause some confusion or offense to it, or further unnecessary extension?
Yes, because, well, as a matter of interpretation, every word or provision in a bill is supposed to have meaning. So to provide what is essentially just a duplication of what's already there, there would be no reason for it, and then we'd be hard pressed, and a court in interpreting it would have to try to attribute some meaning to it other than that it's a duplication of what's already there.
Okay. I hear you. I'm just thinking about somebody reading this and wondering whether somebody would read the processing of data to be the same as obtaining data unlawfully.
It's the definition of
I
processing.
mean, you want to make that so clear. You want to make it clear, because if you could obtain data lawfully and then process it in a way that is unlawful.
Yeah, the definition of process includes obtaining.
Okay.
All right.
And Chair,
Would it be good to give a few examples of the situation here where the data subject can ask for the data processor not to continue? Would it be like in the case of a loan application with a bank? That's one case, if you decided, right?
that would be an excellent example, provided that excellent example, full stop. Just wanted to add, however, that there are circumstances in which, based on the contractual arrangements that you would have had with the data controller can continue to process because of the nature of what your contract says. But if, for example, you have just walked into a financial institution and you have started the process and you have provided them with personal data, you haven't signed any loan agreements with the bank or the financial institution, and you're just simply in an exploratory phase, then you should be able to go in afterwards, that loan officer, and to indicate that we have not entered into any kind of contractual arrangement. I no longer need the facility that I was negotiating with you. I'm going to ask you to kindly stop processing my information, and I dare say return the information to me, because it's mine, my data.
Chair, another potential example of this stress in some of the research that we did, we had come across a case where a family they had lost a member of their family in very gruesome circumstances, and it was a very public event, and it was reported in the news and was in the papers and so on, and the family felt that it was causing them serious distress, and they actually approached the court. So I don't recall the jurisdiction, but it would have been somewhere in Europe, where the GDPR and the data protection standards on which we're basing some of these originates, and the court accepted that it was causing the processing of the data in the way it was done was causing the family distress, notwithstanding the very public nature of it, etc. And they granted an order allowing providing for the data processors to cease doing what they were doing. So that's a context in which it could also arise.
I was asking if that's the Google Spain case.
I don't recall the name of the case. I'm going to check my records to find it. But what I came across, it was an interesting example of a circumstance in which a provision like this could be useful to individuals.
Okay, if there are no objections to clause 10, We'll move on to clause 11, which is our right as data subjects to prevent processing for purposes of direct marketing. And I'm sure you've seen that already in some of the social media platforms that you use, but we'll go through that here again for our purposes.
All right, thank you very much, Chair. Another right which the bill provides for is the right of the data subject to indicate to a data controller that you are to stop or not to begin processing my data, where your purpose for doing so is that you would like to market your products to me. And direct marketing means advertisement in any form at all. That's the nature of the definition. That is here. The concerns which were raised by our stakeholders is that we should, one, remove this restriction altogether. Because what you are doing is that you have actually prevented, and the telecommunication stakeholders in particular raised this concern, you're actually preventing them from being able to market their products even to their own customers. Because what you are allowing customers to be able to do is to opt out essentially of receiving material and marketing information that they would like to share with you. Other stakeholders were concerned that we had included in the legislation an opt-out methodology by way of verbal notification, and they felt that if it is that a data subject wanted to opt out, that they should be required to do so in writing, because proof of a verbal request may be difficult for them to show later on. And also, it was suggested by one stakeholder that the requirement that the legislation has, where it says within a period that is reasonable or properly to be defined, and they said so in the way that they would have structured their recommendation, that they felt that a period ought to be included, for example, a period of 30 days. The ministry would have assessed the recommendations, and our recommendation is generally that there should be no change to this clause. We heard concerns that were raised that perhaps what should happen is that it should really be an opt-in regime, that data subjects should be required to opt in to receive direct marketing information rather than even opt out. So one entity would have, or some of the concerns that we heard was that we should have gone even further, and rather than have an opt-out regime, we should have really had an opt-in regime, that I had to indicate that I wanted material first before you were able to send me material. As it's currently worded, what is here is that the material can be sent, and then you can indicate, I do not want you to send me any further information, or if you're aware that direct marketing information is likely to be sent to you, you can indicate to them even before they start processing for that purpose, please don't process my information for that purpose. We felt that we ought properly to keep to our opt-out regime, because it was similar to what currently exists in our Electronic Transactions Act, where Section 29 of that legislation provides a similar scheme, where it is that you can opt out essentially of receiving electronic communication which is geared towards marketing and advertising, and we felt we should keep that regime. We did not, so one, we're not recommending that the restriction be removed, this right be removed, we're saying no. We also don't think that we should limit the right to only written requests, and that oral requests ought properly to remain. It is our view that we shouldn't require our data subjects to have to put everything in writing first, in order to, in particular with this clause, in order to be able to opt out of receiving marketing information. A telephone call should be sufficient to the data controller, who within its internal systems ought to note that this particular data subject has requested that his or her data be excluded from further marketing material or marketing information.
Why should I be subjected to your marketing involuntarily?
By that do you mean why should action be required on your part?
Why should the obligation be on the data subject to opt out, rather than the obligation be on the data controller or whatever to request permission to use me as one of their marketing subjects?
Well, yes, I'm smiling because
To simplify it is, why is it that the consumer, who is less powerful than the data, whatever, controller, is the one that the onus is being placed on, rather than the person who is making a profit from my information?
well, that's correct. So it's so the truth is, that has been a concern that has been raised. Why? I mean, already, why do we not have an opt-in regime? And we can start anywhere, and I'm not starting at the point of importance. I'm just starting anywhere. One, some of our data controllers who are stakeholders who actually do heavy marketing and will have indicated that that is how they are able to introduce their customers to services that they did not know that they had, or new services that they want to introduce. They have already indicated that to place a responsibility on them to place this right within the legislation already limits their ability to market to their customers already. They're not even saying that they can't market to third parties. So let me use a telecommunication provider, for example. They're not even complaining that they're unable to market to external consumers who are not their customers. They're saying that even their own customers, someone to whom they already provide service, they would not be able to provide additional information, and already that limits their ability to be able to market outside of doing mass marketing essentially, or which technically is what happens when you send an email blast, but it's a mass marketing campaign. That's one. So we have to balance the interest essentially of the consumer along with the interest essentially of businesses, and to find a way to meet in the middle that allows them to be able to market their products and services to their customers and third parties along with the consumer. That's one. The second thing is that currently, if we should shift the regime here, and I would hear my colleagues saying so, so I was smiling, if we should shift the regime here, this regime in the Data Protection Bill will be at odds with what currently exists in the Electronic Transactions Act. Because in the Electronic Transactions Act, the requirement is an opt-out requirement as well. So it provides that if you send unsolicited commercial communication, then you must give that person the opportunity to decline from receiving anything further. So usually you get a first blast, and at the bottom in very tiny words, you see if you would like to unsubscribe, you can unsubscribe here. You go to another window that asks you, are you sure you want to unsubscribe? And then you unsubscribe, and you shouldn't receive any other or further communication from that particular provider. And so if we should have to create an opt-in regime here, we'd find that we have two regimes operating, and which one is the consumer going to be using? So because again, it is commercial communication that we are talking about here, even though we didn't use that terminology, it's going to be similar communication. So is it that the commercial provider will just say, okay, you know what, I'm going to rely on the e-transaction way. I'll send it to you, and then you have to write to me, and then the data subject is going to complain, but you did not even ask me to process my information in this manner. So we think that to ensure that across our jurisprudence, to ensure that there is, I wouldn't say similarity, that we perhaps would keep an opt-out regime. And then the third reason I would want to posit for keeping the regime as is that we have to balance responsibilities within the legislation. Already this legislation, though it exists to protect the rights of data subjects, places a heavy, I use that word very loosely, places a burden essentially on the data controller to ensure that you comply with standards, that you register, indicate what you are doing, and also respond to requests. We're saying in this instance, what we're trying to balance is that the responsibility will remain on the data controller, but just that the responsibility chips in after the data subject indicates that actually I have a challenge with what you are doing, because it may very well be that a data subject is fine with receiving additional advertisement, additional information about products and services that a data controller would have, and some persons may and some persons may not.
Why is the onus being placed on the consumer when a profit-making entity is getting my information, using it to make money, but I, the consumer, who has no knowledge that they have gotten my email address has to then take time out of my time to tell them in whatever convoluted way they may construe their opt-out provision to say, do not send me any more text messages or emails or whatever. And the second question is, when was the Electronic Transactions Act passed? I guess the issue I have is I've always seen the consumer as the least powerful in the regime. The consumer is the individual versus a large company that has a lot of resources. You're giving the large company that have a lot of resources a first bite at me, and then I have to know, without my willingness, knowledge, or permission, then I have to now turn around and go to them and say, please take me off your list or whatever. I'm wondering, I'm trying to understand the philosophical reason why we would want to disempower the consumer and empower the company.
Kadian, I don't think we're disempowering and empowering. As Kadian said earlier on, this is a new regime that we're entering, and to try to turn the basket upside down right here from the beginning, I think it would just be pandemonium. It's again, the things that we're doing, we're looking at other jurisdictions to see how they've done it. It's new for everyone, and we don't want to go out the chute, doing things that will just upset everybody everywhere about it. So that's the best example I can give.
Chair, if I may also add to that, we didn't come to this position lightly. We would have done some research, as our research findings would have indicated, and so we found that most jurisdictions tended to have an opt-out regime. We found in our research that it was only Canada and South Africa that would have had an opt-in type regime. And so we were recommending the opt-out because that tends to be, I'm so sorry, what it is that it obtains across most data protection regimes.
Do the regulations have some specificity as to how this works in terms of the opting out? Because one of the things which was said, which I'd have to concur with, is sometimes these things are so convoluted that by the time you finish asking me 5 questions to opt out, I'm just like, oh, I'm in. Send me whatever. It's easier to just delete them as they come. So I don't know if the regulations will do so. Secondly, I can appreciate the commercial value for the companies with me being their existing customer, not a third party using my information. But if I'm a customer of a particular telephone company, I can appreciate them wanting to send me something. Maybe I might even want them to send me something. But one of the things is they would have the option of giving me a specific, in the opt-out, giving me their specific option to opt out. Like, they may not want to give me an option to get weekly emails, an option to get one per month. How does that work within the context of this? Is there something we can do to ensure that the consumer can manage that process better?
Excellent question, but recall the way our legislation is currently structured. It's simply for the data controller, whether in writing or verbally, to say, I no longer want to receive any more information. Do not process my data any further for the purpose of direct marketing. So it's an email essentially provided to so it has to be 2 things that run concurrently. An email or a telephone call to the particular data controller is sufficient for that data controller to have to stop. And if it is a data controller does not stop, the legislation provides a scheme for you to make a complaint to the commissioner. And that is in 11.3, because you can apply to, it says if the commissioner is satisfied upon the application of an individual that the controller in question has failed to comply, then the commissioner can take steps that will allow the controller to comply with what it is that you have asked. So the scheme here is actually very simple. It's actually saying if you pick up the phone and call, stop processing my data or don't even begin processing it, then that is fine at that particular point in time. So there's no, I wouldn't suggest that we add any other layer on top of this to create any mechanism. I know that that was also a question that was raised by one of our stakeholders, and so we'll note that Jamaica Computer Society and JITSA, for example, would have suggested at page 47 of the matrix that specific requirements for withdrawal ought to be set out in the data protection law. It's not our view that any further specific requirements ought to be here at all. And in addition to what is here, this is complementing what already exists in the Electronic Transactions Act, which specifies that where you're sending unsolicited communication, you ought to provide a means by which the person can unsubscribe from receiving that. So these two things will be going in tandem.
I just want to make clear, this clause treats the third party marketing the same way as, well, because I'm looking at the definition.
Correct,
right?
it does.
It treats, if I'm a company, it treats marketing from me the same way as one of my affiliate companies that I would want to send information to you from. Right? Is that correct?
Correct. The word individual is used across the board, so it's not speaking to your specific customers or your specific customers means anyone.
Just for my clarity, if you're finished, does the GDPR offer opt-in option? Does it speak to opt-in in the GDPR?
The GDPR offers an opt-out approach. It says that where personal data are processed for direct marketing purposes, the data subject shall have the right to object at any time to processing of personal data concerning him, which includes profiling to the extent that such is related to direct marketing. So the GDPR also offers an opt-out approach. No.
Generally, direct marketing email messages may be sent only to recipients who have given their prior consent opt-in. All recipients express prior permission. Maybe it's wrong, I don't know. I just wanted clarity.
All right, thank you.
Yeah.
So if there are no objections to clause 11, we'll move on to clause 12, and that is another right that we will have as data subjects in relation to automated decision making, and the clause gives some example of what that is. And probably the best one would be the algorithm used, to assess creditworthiness. That would be an automatic decision-making process, and there are certain rights that we have in the regime that we can require for decisions not to be made based solely on automatic decisions. And for this, I know we had quite a bit of, there are about 6 entities that responded to this, sent in their concerns.
Thank you very much, Chair. This clause as well, as the Chair would have indicated, raised a lot of concerns, and we got concerns from telecommunication providers and from the credit bureaus, as well as from Jamaica Computer Society and the Bankers Association as well. Most of the concerns that were raised were as follows. One, that they felt that this particular clause was onerous and costly to companies because you were asking companies essentially to provide information to the data controller that perhaps is not information that was within their purview. So, for example, credit bureaus were concerned because the nature of their business is that they use information or data from various sources and they process it in a particular manner, process that information, and then a score is generated. And it was their view that the score was considered a decision, and they were now going to be asked to provide information about this decision that they would have arrived at. Other stakeholders indicated that the companies would have had to employ, or would have to employ, additional staff and additional resources in order to comply with this particular provision. And another stakeholder was concerned about the time period, that they thought the time period was different for data controllers versus data subjects, that the data subject had less time to make a complaint and the data controller, had more time within which to respond. Another stakeholder was concerned about how this particular clause would affect data mining, and because data mining being big and new business, it was concerned that the nature of how the clause was structured, it would prevent data mining by companies which use large data sets. And again, the deposit-taking institutions were of the view that the nature of their business was such that they could not operate without automated processing. And so to give a right to prevent decisions based on automated processing would mean that you're basically telling customers not to accept their services, and they did not think that they should be included among the data controllers who have to comply with this particular provision. And so if I could, Chair, just quickly take us through what the clause says. The clause applies to decisions taken on behalf of a data controller, and this is important, which significantly affects a data subject. Again, it provides an individual at any time by notice in writing to require a data controller to ensure that no decision that will affect a data subject is based solely on processing by automatic means, if it relates to their creditworthiness as well as their reliability or conduct or their performance at work. And if it is that, and this is an important part of this particular provision, if it is that a data controller has not received such a request from a data subject, the data controller is still required to indicate to the data subject that a decision was made concerning him or her based on automatic processing. And if, having so indicated to data subject, he or she receives a request for reconsideration, then the data controller is required to reconsider that decision or to make a new decision because the data subject would have issued a complaint. And again, if the data...
wouldn't you say that the persons who would be concerned, they are the persons with an unfavorable decision, right? So people who have favorable decision, they wouldn't really care about this clause, right? So it's just...
Usually that is the case, Chair, because the legislation goes on to indicate that exempt decisions do not fall within this provision. And one such definition of the exempt decision is a decision which actually grants the request of the data subject, him or herself. So if it is that the decision is favorable, you would not have a reason to raise a concern under this particular clause. So, with respect to that, our recommendations are as follows. One,
Katie, and then the entities who express concern, they shouldn't be that concerned then, because in the normal course of business, let's say a credit rating agency, generally people accept their decision. Right? It's only in maybe a few cases that customers would complain and say, okay, I need more than just this automated decision making.
That's correct. And I think the concern that would have been raised by Credit Info on behalf of Credit Bureau, well, certainly speaking about the nature of credit bureau businesses, was that they're going to fall within the same requirements as every other data controller. So it was their view that a data controller, such as a bank, for example, would take its credit information and should apply to use other information essentially to come to its decision about a customer. However, because it was a data controller itself, it would also be required to respond to any requests or certainly the rights of the data subject which were made pursuant to this particular section. So it was felt that even credit bureaus themselves would be challenged or hard pressed to deal with this particular provision. Our view is that credit bureaus should not be exempt at all from this, because the truth is, or should not be specifically exempted from this particular section, because the truth is this section is speaking about a decision that is taken in relation to creditworthiness, conduct, or employment. And in the nature of how the financial business works is that the score is just a score. The decision is not the decision as to whether or not to provide you with a loan facility is not made by the credit bureau. The decision to provide a loan facility is made by another institution. And that is the institution that is being captured by the terminology here in this clause, not so much the credit bureau.
But technically, well, will guide me now. Let me try and understand what's happening. So if I'm a credit bureau, and I have a software that I utilize because the software is found to be more efficient, more effective. Matter of fact, it is a better predictor than a human looking on it itself and scoring. We are saying in this, and I'm to be guided, we're saying that the credit bureau, if I so choose, if I know I got a bad credit and I don't want them to go through that process, I'd prefer them to have a human being do it, who I can go in and speak to and talk to and nurture them as to why my credit is where it is. This would allow me to restrict the credit bureau from using the software that they think is most efficient in finding my score. Is that it?
No, it doesn't. And I direct you to clause 12.2. So clause 12.2 says an individual is entitled at any time by notice in writing to a data controller to require the data controller to ensure that no decision to which this section applies is based solely on the processing by automatic means of personal data. I'm jumping for the purpose of evaluating matters relating to the data subject, for example, the individual's performance at work, creditworthiness, reliability, or conduct. And so the credit bureau would not be the person who will make the sole assessment as to performance at work, because the credit bureau is providing you with a score.
No, but I could stop them from using the software.
No, you wouldn't be able to, because remember, the way the legislation is structured is that the decision.
So you're saying creditworthiness is not coming just solely from the credit bureau?
That's correct.
So it would be whatever subsequent party that utilizes that score that I could say to them, well, no.
That is correct.
You can't put me in an automatic processor because my situation is very unique and I need to come in and talk to you about it. Don't process me. Is that it?
That's correct. So what would happen is that if you receive a score from a credit bureau, for example, and that score is provided to a third-party entity, you can that score can be provided to you because as a citizen, you're entitled to walk into a credit bureau and ask them, make a request to ask what is my credit score. You can ask that request and that information. If it's provided to you, that is just information given to you. It doesn't affect anything that is written here because it's information given to you as an individual. If the information is given to a third party, because usually when you request a credit score, it's because you're requesting it, a request is made either by you for it to be sent elsewhere, or you have given permission for another entity to request that information about you. The entity that you have given that permission to is the one that is making the decision. And what this is saying is that that entity cannot make that decision solely on the basis of information, which is based on automatic processing. So that if you get a score and the person said, okay, I'm sorry, based on the score, I'm not going to offer you this, or I'm not going to offer you this loan or offer you this job, you can say to that particular entity, no, that I don't want you only to base your decision solely on something which is processed by an automated means. That is what it's saying here. So it is our view that the concern that has been raised by credit bureaus it's not a concern which is affected here, because the decision to which this clause relates is not made by the credit bureau.
So the credit bureau has no reason to worry about 12.1?
No, not here.
It will not affect the core function of collecting information for credit bureaus.
No, it wouldn't. It would not. And not this clause. This clause wouldn't do so. I mean, credit bureaus, like all data controllers, will now have to adjust their businesses to fall in line with the requirements of the provisions in relation to consent and provisions under the law and other things. But this provision is not going to affect them in the way that they have raised the concern. It's not going to do so. To take us very quickly, take us very quickly through the analysis that we would have relied on one stakeholder indicated that they had a difficulty with the term significantly affects. So what the clause provides is that this particular section applies to a decision which significantly affects a data subject. So the question is, what does significantly affect mean? Does it mean I don't get the job? It means I don't get the loan. What does significantly affect mean? The stakeholder felt that the terminology significantly affects was too subjective and not properly to have some more definition. Again, we're of the view that these words are given their ordinary meaning and that really there need not be any further definition essentially of the term significantly affects, but we were rather giving the data subject an indication as to the nature of the effect that the decision should have before he or she lodges or exercises this right in particular. And I indicated earlier that the words decision wouldn't be defined because decision is going to be given its ordinary meaning. The other concern that would have been raised, we already addressed it, which is that the decision was one that was made solely based on automated processing. And again, we were saying that it was not based on the entity that did the generation based on an algorithm, but rather the entity that was making the decision that would be affected. Another stakeholder cited the GDPR and said that they felt that we needed to include the word negative legal effect to be very clear that the effect that we were talking about was one which was negative. We didn't think that we needed to do that. The chair would have indicated earlier. Exactly. A positive effect wouldn't have been, no one would be complaining about a positive effect essentially, or would want to exercise this right if the effects were positive. So we didn't think that we needed to do that or needed to make any change at all. Another stakeholder had again indicated that there was a dichotomy in how in the time periods that would have been provided for in this section. So the data controller had 21 days having been notified, the data subject had 21 days having been notified by the data controller that said, guess what, I just went and made a decision based on an automated processing about you in order to complain. But the data controller had 30 days within which to respond, and it was felt that this 9-day difference was unfair to the data subject, that if it is that a data controller was given 30 days to respond, the data subject ought properly to be given 30 days to as well. And you're given 30 days to respond. And we were saying it's a matter for the committee, so we did say that consideration may be given to giving the data subject 30 days to require the data controller to reconsider any decisions that were made as well. So we were saying that would be fine. Right. Okay.
I just wanted to point out that across many jurisdictions, the example of automated decision making would include things like profiling, where they just take certain criteria and make a decision about you. Yeah. All right. All right. So if you have something else.
Last one, Chair. I wanted to bring the committee's attention to clause, because of the change that we're recommending in clause, I think it's 12.5. Yes, clause 12.5. So the scheme of this particular clause says that if it is that a decision has been taken by a data controller in relation to me, a data subject, then the data controller ought properly to either reconsider that decision once I have said I don't want you so to do, and it follows, because if you have made a decision and I am saying I don't want you to make a decision based on automatic processing, then you should either change that decision or at least reconsider it based on other factors. That's what the scheme is suggesting. However, currently in clause 12.5, it says if the commissioner is satisfied on the application of a data subject that the controller has failed to comply with a notice, either one that the data subject gave before the processing started or subsequent to finding out that a decision has been made, the commissioner may order the data controller to reconsider the decision. The stakeholder was concerned about me, because if the right is given to me to require the data controller to either reconsider or to change, then the information commissioner, should be required to tell the data controller reconsider or change. So by using the word may here, it suggests that the information commissioner has a discretion as to whether or not he or she will direct the data controller to reconsider the decision or to change it, and that runs contrary to the right that I have been given in 12.2. And so the...
What is the international comparisons? Because I gather perhaps what they're trying to do is simply take into consider or contemplate situations in the future where there's a failure to comply, but maybe not an egregious failure, or maybe not a failure which is, or maybe one which can be sufficiently explained, and so they're giving the commissioner that flexibility. What does the international community say?
Well, we didn't. In our research, I don't recall in our research that when we looked at it from the standpoint of how it is that the other jurisdictions would have structured the use of the discretion. The concern here is more a drafting issue, and I use the word drafting very loosely, very, very loosely, to say that if you have given me a right, to have a data controller do X or Y, then if the person fails to do X or Y, then the information commissioner should be required to have the person do what they are supposed to do, which is X or Y. What is provided for here is that the information commissioner may ask the person to do X or Y, and so it's running contrary to a right which I have. Okay. So that would be the way it is done. However, and CPC has provided some guidance, if it is that the committee would prefer to have a residual discretion be given to the commissioner so that the commissioner can either do X, Y, or in his or her own discretion come up with an alternative which is Z, then that could be included.
Well, what would assist us is perhaps an understanding of what could be. What are some of the examples of what this could be? What are circumstances that we're thinking about? And would that flexibility be useful? I mean, I gather that is perhaps why it was there, to have the flexibility, but we'll lean on your understanding of the potential issues that could arise.
Automated
data. Is it something that you would want the commissioner?
Can I give you an example? I don't know of that.
You understand what I'm saying?
One moment, Chair.
You get what I'm saying? I'm saying here it's not hard to appreciate that if you don't do something and the commissioner is satisfied that you haven't done it, that the commissioner has the authority to tell you to do it. Here it is saying the commissioner may. So is it useful for the commissioner to retain some flexibility in these circumstances? What are the circumstances that we're looking at? That's what we would ask for you to guide us on.
All right, Chair, we could do some further research to see if it is that there are other jurisdictions which would have given a residual discretion to the information commissioner or such entity in circumstances where, especially in relation to automated processing, you have acted in this particular manner and there is an option other than reconsider or change what else it is that the information commissioner could do. So we can check.
And I just say so because these things are always evolving, right? A lot of these structures you find are evolving with technology and time, and so perhaps it may be useful for a commissioner to be able to have that flexibility. But again, guide us, because if it is something which you feel requires some kind of strict determination, then perhaps at that point would be swayed to say shall.
So, Kadian, is it that the flexibility to the commissioner is assuming that they may get an overwhelming number of persons, and so they would decide if it's relevant, not relevant, significant, not significant?
Chair, I don't think so. I think what this particular, certainly our interpretation of this particular provision was that we were ensuring that the right that the data subject had was a right that could be enforced by the information commissioner without more. And so whether it would have been 1 or 2 or 3, it would have been across the board. But we didn't honestly look at other circumstances in what else could the data information commissioner order the data controller to do outside of reconsider or simply not make the decision. So I think that we could look at it. Honestly, at this point, I'm not coming up with any other examples as to what else they could really do. I really can't, but I mean, there may very well be, so we could look at it and return at the next sitting, which is next week, to indicate if we haven't found anything, then the residual discretion, which is suggested, it may not lead us any further, or it could. So we'd want to do the research just to ensure, to guide the committee on that. So.
So, if there's no objection to clause 12, rights in relation to automated decision making, we'll take the final clause for part 2. It's the final right that we have as data subject. Okay, there's a question. This is what clause was? 12. Clause 12, 3B. Clause 12, 3B. Is it that we're going to change 21 days to 30 days?
Yes.
All right. So we'll move on to clause 13, rectification of inaccuracies and other things, and that is the final right of data subjects in part 2. Yeah.
There were no. You would like me to take you through what they
No,
mean?
fine. There's no change. Okay.
No.
Gotcha. 13.
Clause 13.
Clause 13, Chair and members, this clause represents, as the Chair have indicated, the right of the data subject to request the data controller to rectify any inaccuracy of data, whether the data is in the, of the data that is in the possession or control of the data controller and relates to the individual that is a data subject. My apologies. Here, rectify has a very broad meaning, or it covers a lot of things. It means amending, blocking, erasing, destroying, anything that is required to correct the inaccuracy. We had a lot of comments that essentially were raised in relation to this particular provision. Deposit-taking institutions in particular had a concern that the nature of how their business operates, they would not be in a position to make the type of annotation essentially to the data where it is that which was requested. The Jamaica Computer Society similarly raised some concerns in relation to rectification, and this was relating to consent, as also whether or not the consent that was made, if it was made on behalf of a minor, was consent that was real or informed consent. There was also the concern that was raised about this right to be forgotten and whether or not the right to be forgotten would have been circumscribed or provided for within this particular clause, which again deals with rectification. And then also the process of appeal. What would be the appeal process if it is that there was a request for rectification, and whether or not the appeal process would conflict with other processes provided for under other legislation. All right. Chair, we would have, Before I proceed, though, I believe I want to allow the legal reform division to share a concern that it may. Department, my apologies.
Good afternoon, Chair. Well, we have a challenge with this clause because it seems to be very subjective, as the clause only allows the data controller to rectify the inaccuracy in the data only if they deem it to be something that they would want to correct. So even though the information that they may have is inaccurate, it's wrong, there are omissions, it seems to be too subjective in that it's the data controller who would have to make the decision whether they want to amend it or not. And if they don't amend it, then the individual would then go to the commissioner to make an appeal and to make a case as to why it should be amended. So unlike the UK legislation, where once it is wrong, then the individual has a right to ask that it be changed, and then the data controller has to change it. Here it gives the data controller the allowance to say whether or not they are going to change it.
Right, yes, yes it does.
We are suggesting to remove the discretion on the part of the data controller, because based on the definition of inaccuracy, inaccuracy is any error or omission. Therefore, if the data has error, then I shouldn't need to wait on the data controller to choose to correct it. It should be an automatic thing. If I point out an error to you, you should just and the error, and it can be verified that it is in fact an error, then it should be corrected.
Once you point it out to the data controller, it is the data controller who now determines after their assessment whether they agree or disagree, right?
That is what this act is saying.
Yeah, and you're saying that. Well, I'm trying to understand what you're saying. So, what would you suggest as a substitute to me, the data controller, receiving your submission and saying, okay, I agree with you, let me delete or amend, or no, I don't agree with you, this is not incorrect?
Right, but what I'm saying is to take away the discretion from the data controller whether or not to amend the data if it is inaccurate.
Okay, I got you. Understand. Once it's inaccurate,
it must be done.
Delete it. Okay.
So if I can bring my passport in and show you that my date of birth is wrong or something like that, yeah, then you have to correct it.
He looks disturbed. She cannot. What's the problem?
No, the provision is not giving the data controller an option to not address an inaccuracy if it is in fact determined to be inaccurate. All it's requiring the data controller to do is make a determination. Now, if the data controller does make a determination that is inaccurate, then in accordance with the fourth standard, which is set out in section 20, clause 27, the data controller would have to correct the inaccuracy. But it couldn't be any other way other than as stated in clause 13, because the data controller would have to lend their mind to the issue and make a determination one way or another. And that determination, if the data subject is dissatisfied with, is subject to an appeal to the commissioner. So that is how that would have been addressed on the data subject's end. But the data controller is under an obligation under clause 27 to ensure that data is accurate.
And you say 27? 27 requires that information is accurate.
27.
That's a all-encompassing feature of the legislation. So what if it is inaccurate, according to 27? Because I think that is where legal reform is going. Right? So whether it's 27 or this one, what is the step to be taken if I have inaccurate information and you've guided me that it is?
In addition to that, if you look subsection 5 of section of clause 13 seems to be a clause that serves as the deal breaker between a dispute between the data subject and the data controller. So that if the data subject forms the view that if the data controller does not rectify, the data subject can then write to the commissioner disputing what the decision that the data controller did.
This is the appeal clause.
Right, and then the commissioner makes an assessment whether there is in fact an error that needs to be corrected or not.
Yeah, so my understanding is that if the data controller receives a submission from the subject that there's inaccuracies and fails to act because they have come to a different conclusion than the subject can appeal, right? I still don't know that that's what legal reform is talking about, and you can guide me. I think what they have said is prior to that phase of any possible appeal, if you have received information and find that information to be inaccurate, not that there is a diversion or some divergence in thinking between the subject and controller. Controller receive the submission and say, oh yeah man, it's inaccurate. But then what next does the controller have to do? Am I correct, ma'am? Is that?
Yes, if you look at...
You understand what I'm saying, Jeff? It's not appeal, so they're asking about before.
Right, so if there's a dispute, so the data
there's
controller
no dispute.
should be on an obligation to accept what the subject says.
So it's where there's no dispute.
If the data controller has a problem, the data controller should then go to the commissioner. Is that the line
No,
going down?
what I'm saying is there is no dispute. Controller agrees information is inaccurate. But then legal reform, take it from there. I don't want to.
We look
They'll
at...
change it. They'll rectify. Why wouldn't they?
Out first, so that perhaps I'm articulating it differently than you. Let me hear it just.
If you look at subclause 3, where a data controller receives a request under subsection 1, the data controller shall, within 30 days after receiving the request, determine whether a rectification is required. Right, but but that means that they have a discretion to see whether the inaccuracy that was brought to their attention, whether a correction is required in the data. So that is the discretion that I'm speaking of.
So why I asked for clarity, right, is because it wasn't appeal that they're talking about. They're talking about, I receive a submission that the information is inaccurate. I agree the information is inaccurate. To me, my reading of it is that that's treated with in 3B2, right? Is it? No, sorry. It's treated within the, is it 3B2?
Yeah, for the purpose of...
3B, sorry. So if the rectification is required, make the rectification and give notice of the rectification to the individual making the request, which is the subject or whoever. And so far as is reasonably practicable, every person or entity to whom the data was disclosed at any time. Right? So that's why I'm asking. What are we saying is the issue? You get what I'm asking you? Legal reform? So I agree with you that if if a submission is made and the data controller agrees that there's an inaccuracy, they must act. But you're saying that in your interpretation, this does what? Does not cause them to act?
I believe what she's saying is that the data controller has the discretion to determine whether rectification is required.
But there would be no
not.
other way. So guide
I'm
me.
agreeing with you because I think the data controller would have
Yes, if somebody
to
says
look at
to-
it. Yeah, somebody comes in and says this is inaccurate.
I
You
think the
can't
better
just take
question
it.
would be,
Yeah.
a better question would be, so if the data controller and the subject have a dispute, which is where AG's office was going, but appeal is there. So I'm trying to, you get what I'm saying? I agree with you that it would be a problem if that's the issue, but I'm not seeing the issue here. So is it okay? It's fine? Good? All is well in the world? All right, good. I think so.
Yes.
I think so.
Yes.
Because if that was so, I would have a problem. I just wasn't seeing where it was extracted in terms of this.
Right. So someone has to decide if it's inaccurate or not, right, based on their assessment. And if you think it was a wrong decision made, you have an
But that
appeal.
would make it so cumbersome if you're going to send it to some third party. Initially, it would make it cumbersome. So to me, it makes sense that you would write to me and say, listen, I think you have an inaccuracy. It's not always going to be some controversy. Oh, you have an inaccuracy, sorry. Let me notify the world, and I really apologize. That could be the response. If the response is otherwise, you go to 5, right? Or 6.
Excuse me, and one more thing just to bring to your attention. If I'm going to have to double check the bill, but if there's a cost to appeal the decision of the data controller, that cost would be on the individual if the data controller seeks not to amend the error that was brought to their attention.
And you're saying what? What would be your submission? That the cost be on...
But who gave the inaccurate information? So I would bear the cost? I don't understand.
Guide me, SG.
If I may, this is a normal construct that we have throughout many different laws. When you have someone who has information, a registrar, whoever, you can pick a law that has this kind of construct, and it's always usually set out this way. We also have to always remember Wensbury's principles, which says that an authority is supposed to act in a reasonable manner. So if I approach a data controller and I say there is an error, and the data controller looks at it and realizes there is an error, the way how the law is structured, that data controller would be required to make the rectification. And if the data controller didn't, the data controller would be acting in an unreasonable manner, which is unlawful. But that doesn't need to be so spelled out in the law. What I see here is the usual construct.
And sufficient.
But the point is, I could easily come to the data controller and say the information is wrong. But the data controller could make a determination that no, it's actually correct. And they could set out, because that can happen, that I could actually be mistaken. It's not that every time I approach the data controller, I may be correct. And so this is why you then could go to an appeal if there is a divergence of views. But this is the usual construct. When you're talking about an appeal again, it is again the usual construct that costs must be borne by someone. There are administrative
is there
costs.
the possibility, if it is that I bring the case and I am found to be
Well, that could be
victorious,
something that could be built into the, I don't know what is here now. I don't know how much discretion there is in terms of how you deal with the cost, but that is something that could be built in.
I suspect what legal reform is trying to do is to protect the individual
Subject,
might have.
but the point is the data
inferior
subject may not
pockets.
always be correct, so the law has to build that in as well. You can't make it mandatory that just because I say it's the same thing with RGD. I could go to RGD and say that you have entered the wrong birth date for my child, but there can be reasons why you could be wrong as well. I'm just saying, just because I have made a claim doesn't mean I'm going to always be right. And there has to be someone that's going to make the determination. At the end of the day, the person who's going to make the determination is usually the person who holds the information. But you have to make your case. You have to explain why you think you're correct. If you really are correct and the entity, the person who holds the information knows you're correct, they must make the change. And that's part of common law principles. And then if they don't, you have the right of appeal.
So is there anything we could do to make that consideration in here, in terms of
Consideration in terms of cost?
in terms of the victorious party having the option? Is it
We would have to look
is it
to see
necessary?
what is built
Is it
in terms
necessary?
of the cost. I don't know how I would have to look at it to see if it's even addressed at all, because sometimes we leave those things to rules.
Yes, to see. That's what I'm asking. Is it even necessary? Would it be?
To actually put it in the act?
Well, I'm just asking what was the determination?
We don't normally put those things in the act, though.
So what was the determination? Legal reform. What were you thinking? I'm interested in knowing what you're thinking, because you seem to be wanting to protect the highly likely consumer who is subject to this.
Well, in speaking with the ministry has indicated that they will look at what kind of costing
Provisions
to be provision that will be made, and we'll be satisfied.
So take a look on it and then you can get back to us. Right? Ministry, you'll take a look on the potential provisions that could facilitate this and then get back to us. So we can move forward.
That's what we could do that. Chair, we could look at that, we could, okay. All right, so Chair, in response to the concern raised by the member and Legal Reform Division, what we could do certainly as a ministry is to look at the current fee structure, because if it is that, and I'm hearing the AGC and CPC to indicate that the structure as it is now provides the basis on which for the data controller to determine whether or not, based on the information provided, there really is an inaccuracy, because there needs to be an assessment. And I'm hearing legal reform to be expressing concern, however, about the data subject and the cost imposed. As this appeal processes to the commissioner, we could look at whether or not there's the fee structure here where the data subject is the one appealing. What, if any, would be the fee structure would be imposed, and whether it could be a nil fee structure. We can do some research around this. It would not be stated here, though. This is something for regulations, but we can look at it.
So, all right, MSET will take a look at issues of cost and who would bear the cost if there's an appeal. All right, it is 4:19. We will pick up in our next session, part 3, where we look at requirements for data controllers, including registration requirements, offenses, and so on in part 3. So thank you, everyone. If there is no objection to clause 13 other than what MSET committee do to looking at the cost, we would move on to clause 14 in the next session. So moved? Okay. Meeting is adjourned. Thank you very much.
Matthew? Jesus.
Oh, God.
They're trying to give it to us.
You don't see that too, Diane? You don't see the tweet yet? Attacking the tweet. Look at it.
Oh. So when you make us slap, you make us slap. Bobby, shut up.
Need somebody design some. Yeah, nobody is available this evening. I have to add more on the Sunday morning, and then so I can send in both artwork for whichever one. You can decide which one to place based on movie.
Oh, cool. We have to.
Why you not link? No, I check both Lena and Observer.
You never put up a fight, no. Paradise come. Just know me like we do. We never had to say a word, not a sound. Silence, you baby. You never put up a fight, no. Paradise come. You just know me like we do. We never had to say a word, not a sound. Silence. You never put up a fight, no.
You nobody put up a fight, no. Paradise Plum, and keep it locked to PBCJ. This is your girl Naomi Cowan.
We know times are hard, but can selling your vote really make a difference in your life? How many of them even remember you and your community? What you need is opportunity for yourself and for your children. Don't sell your vote. It is illegal. Respect your vote. Vote for opportunity. A message from USAID Commit to NIA and partners.
We are dealing with yo, respect authority and keep your dreams alive. School us to study, not fi fight. Hey, we need each other. CF school what we are dealing with. Yay, safety is a human right. Don't destroy your own destiny.
Building safer schools in safer communities.
Play it, CF grab a book, link a friend, talk out loud.
A message brought to you by the Safe Schools Task Force.
CF school what we are dealing with.
This message was paid for by the European Union.